Mr Winneke.
Thank you, Commissioner. I appear with Mr Andrew Woods and Ms Megan Tedensor as counsel assisting this Royal Commission. Together with solicitors to the Commission staff, we look forward to supporting you in carrying out the important work ahead of us. As you've indicated, some issues that the Commission is required to investigate have already been the subject of litigation in the Supreme Court of Victoria and appeals to the Victorian Court of Appeal and to the High Court of Australia. Prior to that litigation, an investigation had been undertaken by former Victorian Chief Commissioner of Police, Mr Neil Comrie. Investigations had also been undertaken by the Independent Broad-Based Anti-Corruption Commission and the Director of Public Prosecutions. Victoria Police has carried out its own reviews. We understand that those reviews are ongoing. The officers of public prosecutions, both state and Commonwealth, are doing likewise. Each of those investigations and reviews and the litigation that has been mentioned covered only a part of the area that this Commission has been tasked to look into. However, this Commission will receive the benefit of those other investigations. The Commission is obliged by its terms to cooperate with them and not unnecessarily duplicate the work that has and is ongoing. As you've noted, Commissioner, the circumstances surrounding the recruitment and utilisation of a legal practitioner as an informer to provide information to police, including information about her own clients, have resulted in a number of criminal convictions being called into question. The High Court made it very clear that the conduct of the legal practitioner and of Victoria Police that was considered by the court in that case was highly inappropriate. The court found that this conduct, as you've indicated, corrupted the prosecutions that led to those convictions in a manner which debased fundamental premises of the criminal justice system. It is important to reflect upon why these matters are so significant. In Australia, we are fortunate to have a legal system that applies equally to one and all. Each of us enjoys fundamental rights and protections to ensure our fair treatment under this system. These rights and protections have developed over decades and indeed centuries. They are a very important part of the bedrock that underpins the rule of law in our society. They help ensure that the rights of citizens are appropriately balanced with the powers of the state. Many of these rights and protections are well known. For example, when a criminal charge is brought against a citizen, the prosecution on behalf of the state bears the onus of proving the charge. It must prove the charge beyond a reasonable doubt. This onus on the prosecution sits hand in hand with the right to silence. There is no onus upon a person charged with a criminal offence to prove his or her innocence. Closely related to these protections is the right to independent legal representation. The obligation upon a lawyer is to act in the interests of the accused person and not in the interests of the prosecution. Legal practitioners are obliged to keep certain communications with their clients confidential. They must protect communications which are subject to legal professional privilege. Accused people and other clients of legal practitioners more generally should feel comfortable giving their lawyers full and frank instructions without fear that those instructions will be later used against them. Legal practitioners must not disclose confidential information to others without their client's permission. To do so is not only a grave breach of a lawyer's obligation to the client and duty to the court, but also deprives the client of that fundamental right to silence. Legal professional privilege and associated duties of confidentiality do not only exist in the criminal sphere. Every person who provides information to a lawyer when seeking legal assistance, whether in relation to a criminal offence or more generally, for example, a business or employment dispute, a family law proceeding, or for that matter having a will prepared, every such person has the right to seek and obtain independent legal advice. Except in a very narrow set of circumstances, they can expect that communications with their lawyer will remain confidential and certainly will not be provided to the opposing party. Now, these are not obscure legal rules, but they are at the very centre of the criminal justice system. These rules are known by all of the participants, the police investigators, the lawyers and the judges. If any of these rights are perverted, there is a very real risk that a conviction will be set aside. And if so, the time, efforts and costs associated with the investigation and prosecution of an accused person will be wasted. Equally as importantly, the consequences to victims of criminal activity can be great. Through no fault of theirs, they may be required to undergo additional tribulations of further hearings, or worse, see guilty offenders walk free. It is also of relevance in this Commission to consider the central importance of the duty of disclosure. That is, the duty on the part of the prosecution to provide to an accused person all of the relevant information that it proposes to rely upon to prosecute its case. However, in addition, the prosecution must disclose any information that may undermine the prosecution case. Again, this is a universally accepted protection associated with our criminal justice system. The following pertinent comments were made by the British Attorney-General late last year when he tabled a report that had been prepared following a significant review in that country of systemic failures to disclose information to accused persons. He said this: "The central importance of the duty of disclosure must be seen from the twin perspective of fairness to the accused and as a vital guarantor of a secure conviction. Cases that collapse or are stayed and convictions that are quashed because of serious deficiencies in disclosures are fair neither to the complainant and the defendant nor to the public, and they undermine confidence in the administration of justice." The issues of disclosure are relevant to a number of the terms of reference that the Commission must look into, and I'll return to those shortly when I deal briefly with each of the terms of reference. In summary, the task of this Royal Commission, as laid out by the letters patent, is to determine, without unnecessarily duplicating the work of previous examinations, the nature and consequences of the conduct engaged in by EF and Victoria Police, to consider whether current policies and practices are adequate and effective, and to recommend any further changes that may help to prevent such events occurring in the future. I'll now make some specific comments about each term of reference. Term of reference 1 requires the Commission to inquire into and report on, quote, "the number of and extent to which cases may have been affected by the conduct of EF as a human source." Now, for obvious reasons, this term of reference is prioritised as it concerns individuals whose trials may have been affected, some of whom are in custody. It is proper that these matters be considered with expedition. The Commission is obliged to report to the Governor its findings and recommendations concerning term of reference 1 by the 1st of July of this year. Previous reviews and litigation have identified 7 former clients of EF whose convictions may have been affected. Subsequent and ongoing investigations by the State and Commonwealth Officers of Prosecution with the assistance of Victoria Police have identified further cases. There may well be more. Now, it has now come to light that EF was first registered as a human source by Victoria Police in 1995 and then again in 1999. It is known that EF represented many clients between her admission to practice as a lawyer in 1996 and her deregistration as a human source in 2009. The Commission is currently undertaking the significant task of identifying the number of cases which may have been affected and considering the extent to which each case may have been affected. It's expected that this term of reference will largely involve a review of a significant volume of documents, including briefs of evidence and records of contact between EF and Victoria Police. It will be necessary to examine, amongst other matters, what information was conveyed by EF to police, whether that information was confidential or subject to legal professional privilege, the manner in which the information was deployed in the investigation and prosecution of persons, and what other untainted evidence was available to the prosecution in each case. It will also be necessary to examine the conduct of the police officers who obtained that information and that of their senior officers. In this respect, there will be overlap between the first and the second terms of reference. Amongst other materials that the Commission will examine are source materials, including original voice recordings of discussions between EF and her police officer handlers. The Commission has access to those documents and also diaries, electronic and handwritten, which will also evidence communications between EF and police handlers. These materials will be examined closely in order to determine what information was provided, whether it was provided in breach of duties and what use it was put to in ongoing investigations and prosecutions. It's expected that all relevant witnesses will be examined, whether voluntarily or by compulsion, using the powers available to the Commission in the Inquiries Act to which you've referred. The Commission is in communication with EF by her legal representatives, and it's understood that she will be cooperatively assisting the Commission in its investigation. Relevantly, since the establishment of the Commission, it has issued more than 40 notices to produce upon individuals and entities. Those notices compel the production of documents which will assist the Commission in its task. As documents continue to arrive, it's expected that further notices will be served, and that process will be ongoing. In considering the extent to which cases may have been affected, it's important to remember that the Commission does not itself have the ability to overturn convictions or release a person from custody. That's a matter for the courts, as the Commissioner has mentioned. The Commission's powers are limited to the powers set out in the Inquiries Act and by the scope of its terms of reference. Any actions taken in response to the Royal Commission's findings or recommendations are matters for the relevant individuals and agencies. If any person believes that his or her case may have been affected by the conduct of EF, they are encouraged to make a submission to the Commission. As you've pointed out, Commissioner, at this stage it's not possible to publicly identify EF by name. Now, that position may or may not change. However, it's expected that an examination of documents gathered by the Commission will identify, if not the entire catchment of persons whose cases may have been affected, a majority of them. The Commission has the ability, and indeed a vast majority, the Commission has the ability to privately identify EF by name to those persons, and it will make every effort to communicate with each such person and give them an opportunity to make a submission. Anyone seeking to challenge a conviction or sentence, in addition to contacting the Commission, should seek independent legal advice concerning avenues that may be available to them. As set out in the letters patent, the Commission must take care not to prejudice any ongoing investigations or judicial proceedings. The Commission cannot exercise its powers in a manner that would be in contempt of court. Accordingly, there may be matters that come to the attention of the Commission that cannot be fully investigated or mentioned in the Commission's reports. While the Commission acknowledges the need for an open and transparent consideration of the matters under examination, these are important constraints that it must take very seriously. The Commission is also obliged to promptly notify the State and Commonwealth Directors of Public Prosecutions of any information it receives related to their functions, importantly, including their functions of disclosure, relevant to material to an accused or convicted person. That step has already been taken in relation to some information that has come to the attention of the Commission so far, in particular the information that EF was first registered as an informer in 1995 and the existence of other informers that may have had legal obligations of confidentiality or privilege to which you have referred. Term of Reference 2 requires the Commission to examine the conduct of current and former members of Victoria Police in their disclosures about and recruitment, handling and management of EF as a human source. It is envisaged that the relevant issues will be examined at least in part in public hearings. The Commission will likely require the attendance of individuals involved in recruiting and managing EF as a human source, and those involved in the management and oversight of handling human sources generally. It is instructive to have some understanding of the background of the use of human sources within Victoria Police and the state of affairs that existed during the time that EF was a human source. In this regard, the Commission will derive considerable assistance from the work performed by earlier inquiries over the years that have touched upon the use of human sources. It's apparent from internal Victoria Police reviews and Ombudsman Victoria reports that in the early 2000s, Victoria Police was aware of continued problems relating to corruption within its drug squad. In 2001, a review of the drug squad was commissioned. Thereafter, a number of other operations, reviews, reports, recommendations and indeed criminal prosecutions of members of the drug squad followed. Amongst the issues that came to light were problems associated with the use of human sources by detectives. By November of 2001, one of those reviews recommended the adoption of a new informer management system with audit and compliance safety mechanisms for greater accountability. A May 2003 Ombudsman's report also outlined various issues within the drug squad, including that it used unstructured, secretive, unaccountable and sometimes unprofessional methods in handling informers, that members had not been appropriately supervised, that there was little, if any, control over informers, that there were two different policies relating to the use of informers, one for the crime department and one for other departments. There was a recommendation to establish a new informer management unit with audit and compliance measures. In June of 2004, a further Ombudsman's report indicated, amongst other matters, that Victoria Police had by then established the new Informer Management Unit, known as the IMU, with a new, quote, sterile corridor, unquote, approach to managing informers, and that a new Chief Commissioner's instruction on informer management policy had been issued in September 2003. Now, the Commission understands that in November 2004, a pilot unit, the Source Development Unit, was set up within Victoria Police. This was a unit designed to enable the proactive, targeted recruitment of new sources. Members of Victoria Police travelled interstate and overseas for the purpose of gathering information to establish a best practice model for the SDU. In 2004, it's understood that a representative or representatives of Victoria Police were sent to the United Kingdom for this purpose. Now, it's apparent that the UK Home Office had issued a code of practice in September of 2000, which provided, quote, guidance on authorisation or use or conduct of covert human intelligence sources, unquote, by public authorities. This code contained comprehensive procedures dedicated to issues which might arise in the event that a human source was a legal practitioner or subject to obligations of legal professional privilege. It stated, amongst other matters, that, quote, where there is any doubt as to the handling and dissemination of information which may be subject to legal professional privilege, advice should be sought from a legal advisor before any further dissemination of the material takes place. That code of practice also stated at paragraph 3.5, quote, legally privileged information obtained by a source is extremely unlikely to ever be admissible as evidence in criminal proceedings. Moreover, the mere fact that use has been made of a source to obtain such information may lead to any related criminal proceedings being stayed as an abusive process. In addition to the publication of the Code of Practice, in November of 2002, the English Court of Appeal handed down a decision, R.V. Robinson, in which the members of the court recorded their concern about the use by police of an employee of a legal firm to inform on that firm's clients. The Court of Appeal expressed similar concerns to those expressed by the courts in the litigation to which you have referred already, Commissioner. And they called for submissions from the prosecution and the relevant Chief Constable concerning whether it was, quote, sought to justify the practice and if so, on what basis, unquote. Senior Counsel for the Police, in responding to the court, referred to the Home Office Code of Practice and informed the court that, quote, in today's climate, the employee in question would not be registered as an informant. He referred to the use of such an informant as being fraught with danger. The Commission will investigate whether Victoria Police was aware of this code of practice and whether any legal advice was sought by Victoria Police at any stage before or during EF's registration as to the appropriateness or otherwise of her use as a human source or the use of information received from her. Further, as seems from the court processes leading to this Royal Commission, the status of EF as a police informer and the information that was provided by her to members of Victoria Police was apparently not disclosed to accused persons or to the State or Commonwealth Director of Public Prosecutions, to whom it should well have been disclosed, so that appropriate decisions could have been made concerning the ongoing conduct of prosecutions. The Commission will examine whether this apparent situation is in fact correct, and if so, why there was no such disclosure. Term of Reference 3 requires the Commission to inquire into and report on the current adequacy and effectiveness of Victoria Police's processes for the recruitment, handling and management of human sources who are subject to legal obligations of confidentiality or privilege. The Commission will obtain and review documents which set out current processes and will seek evidence as to the efficacy of the same. It expects to conduct private and public hearings into the relevant current processes in order to determine whether they are adequate and effective. In doing so, the Commission will need to consider precisely how many other human sources Victoria Police are using who are subject to legal obligations of confidentiality or privilege. Term of Reference 4 requires the Commission to inquire into and report upon disclosure obligations of relevant human source material to prosecuting authorities. The Commission will consider whether there are adequate safeguards in place when offences are prosecuted where relevant human source material has been utilised. Term of Reference 5 requires the Commission to recommend measures to address the use of any human sources other than EF who were or are subject to legal obligations of confidentiality or privilege. Commissioner, as you've mentioned, information that has recently come to light suggests that police may have used other informers who are in a similar category to EF. This has led to a broadening of the scope of the inquiry, which is reflected in the 5th Term of Reference. I should say this at this point. Although the Commission must report on 1 July only about the cases that may have been affected by EF, the Commission regards Term of Reference 5 as being broad enough to enable it to inquire as to whether other proceedings may have been affected by other informers with similar duties to EF. The Commission intends to make similar inquiries with respect to other informers and, at the very least, bring relevant information or documents to the attention of the State and Commonwealth Directors of Public Prosecutions. As you've already indicated, the Commission has sought and received additional details from Victoria Police about other informers who may have had access to information that was confidential or privileged. You've outlined the information provided. Additionally, the Commission has asked Victoria Police as a matter of urgency to provide information as to whether any persons are currently in custody as a result of the conduct of such informers, and we understand that this information will be provided shortly. The Commission will consider any relevant systemic failures within Victoria Police and the broader criminal justice system in order to recommend how to avoid these failures in the future. It is expected that the Commission will rely on international and Australian experts and will conduct its inquiries largely by way of public hearings following the receipt of reports and submissions in relation to these issues. If I could now briefly comment on the use of human sources in the criminal justice system, as it is a feature of law enforcement that, for good reason, is rarely subject to public dialogue. The term human source generally applies to a person who covertly supplies information to police about crime or people engaged in criminal activities. Human sources are of fundamental importance to our system of criminal justice. There have been many cases throughout history where substantial wrongdoing or loss of life has been prevented owing to information provided by human sources, informers it is. It has been said that one of the most effective weapons in the hands of the detective is the informer. However, the use of human sources also carries risks that must be managed carefully. Great harm may come to a source if their identity or the fact of their informing becomes known. Moreover, if police cannot adequately protect human sources, others with intimate knowledge of criminal activity may be less willing to come forward and to share information. There is also a risk that human sources, the majority with a criminal history themselves, will seek to exploit their relationship with law enforcement to engage in further illicit activity or gain some other advantage. Another risk is the reliance on untested, unreliable or tainted evidence proffered by a human source which in turn has the potential to lead to wrongful convictions or failed prosecutions. Those risks are magnified where the human source is someone bound by legal obligations of privilege or confidentiality. Commissioner, law enforcement agencies must have stringent policies and procedures in place to guard against the risks that attend the use of human sources. Generally, this includes robust management and supervision of the officers in contact with sources, adequate training of those officers, and diligent and secure record keeping. It includes rules that prescribe the manner in which officers may engage with the human source, the scope of their authority and discretion, and how the information obtained from a source should be used and disclosed to other parties. It also includes effective oversight and monitoring so that the use of human sources is subject to rigorous and ongoing security. In some jurisdictions, special rules and safeguards exist for human sources who are privy to confidential or privileged information, including doctors and lawyers, journalists and members of the clergy. This recognises the specific and significant risks associated with human sources who have legal and professional obligations to keep certain information confidential. The Commission will look closely at national, international experience and examples of best practice as part of the inquiry into terms of reference 3 to 5. In addition to assessing the current adequacy and effectiveness of Victoria Police policies and practices, the Commission will look to the future and seek to identify any further measures needed to ensure the proper and principled management of human sources. Commissioner, I will now speak briefly about how the Commission intends to conduct its inquiry into these matters. As I've indicated, the letters patent require the Commissioner to report on term of reference 1 by 1 July 2019 and on the remaining terms of reference by 1 December 2019. The timeframes are ambitious. A very substantial volume of information must be collected and analysed in forensic detail. This task has been made more onerous and complex by the disclosure that EF was registered as a human source in 1995, 10 years earlier than understood when the original letters patent were drafted. In carrying out this task, we will be reliant on many agencies and individuals for the timely and transparent provision of information. Their cooperation is critical to the ability of the Commission to meaningfully examine and draw conclusions about the matters set out in the terms of reference. It will provide the basis on which the Commission can form clear advice about the number and extent of cases affected by EF's conduct. It will also help to ensure that any policy or process changes recommended by the Commission are well-informed, practical and operationally sound. As you've indicated, Commissioner, we will seek information in a variety of ways. We're now calling for public submissions, and from Monday 18 February people will be able to make these submissions via the secure online portal on the Commission's website. The due date for submissions on term of reference 1 relating to cases affected by the conduct of EF is Friday 8 March 2019. The due date for submissions on the remaining terms of reference is Friday 5 April. We encourage individuals and agencies who can contribute to the investigation of the various terms of reference to make submissions. While the Commission prefers submissions to be public, people may opt for their submissions to be treated as anonymous or confidential. If anonymity is requested, identifying details will be removed from the submission if it's referenced in the Commission's reports or published on its website. If confidentiality is requested, the submission or the confidential parts of it will not be published or quoted by the Commission. Commissioner, more information about the submission process is available on the website. The Commission will also draw on compulsory powers given to it under the Inquiries Act. As indicated above, these include the issuing of orders in the form of notices to produce documents and notices to attend the Commission to give evidence. It is an offence under the Inquiries Act to refuse or fail to comply with a notice without a reasonable excuse. More information about a person's obligations in response to a notice to produce can be found in the Inquiries Act and practice directions published on the Commission's website. Individuals required to give evidence at public or private hearings will be issued with a notice to attend. The Commission has also sought initial applications from people wishing to be granted leave to appear at public hearings. The Commission intends to call for further applications throughout the inquiry as the scope of a hearing or series of hearings is determined. The Commission will generally not grant unconditional leave to appear. Most grants of leave will be confined to matters in which the person or organisation has a direct or special interest. Where a person is granted leave to appear, he or she may make a further application for leave to tender evidence or to cross-examine a witness. The Commission will not grant any general open-ended right of cross-examination or tender of evidence to any person. More information about these procedures, again, is available in practice directions on the website. The Commission will carefully consider applications for leave to appear which indicate that a single legal practitioner or law firm seeks to represent multiple persons or entities. Generally, the Commission expects that legal practitioners and law firms will not represent multiple parties. Otherwise, the legal practitioners or law firms will need to satisfy the Commission that any conflicts of interest or potential distortions of evidence will be avoided. Whilst we expect to hold a considerable number of public hearings, which at this stage we intend to commence in the latter part of March, we also anticipate that much of the Commission's work will involve the close analysis of reports, tapes, transcripts and other documents away from the hearing room. It's anticipated that some of the Commission's hearings may need to be held in private. The matters being investigated by the Commission involve sensitive information about criminal activities and police operations. In addition, evidence received by or presented to the Commission may refer to current or anticipated court proceedings. As an investigative body, the Commission can determine whether, when and to what extent it will disclose information obtained in its inquiry. When clearly necessary for legal, privacy, safety or other reasons, the Commission will restrict the disclosure of some information. In addition to holding hearings in private where required, the Commission may make orders to prohibit publication, may elect not to publish specific material on its website or in its reports, and may need to redact submissions, transcripts, witness statements or other documents prior to publication. Obviously, that will be kept to absolute necessity. The Commission will also be supported by a comprehensive policy and research program. It has commenced the work of gathering and analysing relevant materials, and it has sought the assistance of law enforcement agencies in other jurisdictions to build an understanding of contemporary policies, procedures and best practice in the use of human sources. The Commission is likely to call on experts in relevant fields and hold roundtables later in the year to draw on their insights and experiences. Again, I wish to emphasise our reliance on relevant agencies for their cooperation and assistance. We are acutely aware of the sensitivities of operational procedures guiding the use of human sources and of the need to deal carefully with this material. We will use the full range of options available to the Commission to appropriately manage information provided by those who are willing to share their expertise and lessons learned. Can I indicate that certain bodies and public officers are not amenable to the investigative powers of the Commission? Those include the IBAC, Victorian Director of Public Prosecutions, Crown Prosecutors, Judicial Officers and the courts. However, those bodies and public officers are not prevented from voluntarily assisting the Commission where it is within their powers and capacities to do so. Already the Commission has been assisted by the voluntary assistance from such bodies and officers, and it is confidently expected that such voluntary assistance will continue in order that the matters that are the subject of the letters patent can be effectively and efficiently investigated. Today I've endeavoured to outline the processes by which we expect the Commission to run. We will continue to inform the community via the Commission's website of the Commission's work and direction as the inquiry progresses. As I previously indicated, the timeframes set out in the terms of reference are tight. The date of 1 July 2019 for reporting in relation to term of reference 1 was set down when it was understood that EF commenced acting as a human source in 2005. We now know that that commenced about 10 years earlier. Clearly, the work involved in relation to Term of Reference 1 has now significantly expanded. Further, the Commission has issued a large number of notices to produce, and the documents captured by those notices to produce number in the hundreds of thousands. The existence of suppression orders made in parallel legal proceedings have affected the Commission's progress. Whilst the Commission's strong preference is to meet the reporting deadline in the terms of reference, it will not sacrifice an appropriately thorough investigation in order to do so. If and when the Commission forms the view that it cannot properly report in the time available, it will request that the Government provide it with further time. In closing, the significance of the issues involved in this Royal Commission cannot be understated. The legitimacy of our criminal justice system relies on the process being fair and even-handed. It follows that the work of the Commission is relevant not just to the individuals whose criminal convictions may have been affected by any improper conduct of VF and Victoria Police. Much greater and more fundamental principles are at stake. All members of the community, including, importantly, the victims of criminal activity, must be able to trust that the justice system and the individuals working within it, including police investigators and legal professionals, will adhere to the highest standards of integrity and propriety. Commissioner, we look forward to assisting the Commission to understand the events that form the basis of this inquiry, the consequences arising from those events, and what more can be done to guard against similar events occurring in the future. Together with solicitors to the Commission and the staff of the Commission, we assure you that you will be well supported in this important undertaking. Thank you.
Thank you, Mr Winneke. The Commission, as Mr Winneke has indicated, hopes to hold public hearings as soon as practicable. Details of hearing dates will be published nearer the time on the Commission's website. Adjourn the hearing of the Commission to a date to be fixed.
All stand. The hearing of the Royal Commission into the management of police informant is adjourned to a date to be fixed.